problem.
Whether or not you are.
All right, good evening, everybody. I would like to call this meeting of the Riverside Board of Zoning and Appeal to order. The time is 6:01. At this time, we'll have the roll call. Madam Clerk, please proceed with the roll call.
Mrs. Carpenter? Here. Mr. Cron?
Here.
Mr. Gosnell?
Here.
Mr. Chieford?
Here.
Mr. Walling?
Here.
All right, next we're going to move to, there's no absent members, so we're going to move to additions and corrections to the agenda. Does anyone have any amendments or additions to propose to the agenda?
There are none.
Thank you. No further corrections. The motion to approve the agenda is presented.
So moved.
Thank you. And seconded by?
Yes.
Thank you. All in favor, say.
Aye.
Any opposed? Motion carries. Agenda is approved as presented. If there are no additional proposed amendments, is there a motion? I'm sorry, that's for changes. Approval of minutes.
I just got one correction on the adjournment.
Wait.
Point of order, guys.
Chair, there's a agenda item for election. Since
Oh,
this is the
sure.
first meeting of the year, there's an election of a chair and vice chair. So you'll want to open the floor for nominations for one of those roles.
I was trying to skip that part.
I know you were.
I thought he was going to get away with it.
Trying to inherit the role. All right, so, see, I didn't see it right here in my stuff, so I was continuing to move on. Election of chair and vice chair. Nominations for chair.
Nominate Tim Crum.
Second?
All in favor?
Aye.
Aye. Any opposed? All right, wonderful.
You already were in favor, you can't do both.
Oh, gotcha. Vice chair,
Martin?
second?
Second.
Second. All approved?
Yes.
Motion carries there. Yes?
Yes.
Okay, good. You opposed to? All right.
There you go.
Are we good with that?
Yep.
We can move on now to the approval of the minutes. Minutes were distributed in advance. Are there any corrections? Martin, you had something?
I did, just something very minor on adjournment. Vice Chairman Walling, not Crone.
Well, I'm sorry, I didn't hear that.
At the adjournment, noted
Oh,
as,
there's,
yeah.
being nice, yeah.
With
Any-
that correction, I make a motion to approve.
Second? Yes?
Yes.
All right. All in favor, say A.
Aye.
Or aye. Any opposed? All right, the motion passes, minutes are approved. All right. Now, we're going to go ahead to the public hearing now, items, all right? Just a reminder to everybody, before we move on to public hearing, a quick reminder, please adjust your microphone, speak directly into it when making public comments. This helps ensure that your voice is clearly heard by everyone, captures your testimony for the minutes, as well as those on the recording. Any speaker will be testifying under oath, as this is a public hearing, and you must read the oath located at the podium. Those wishing to provide comments on one of the agenda items must complete the speaker form located in the back, submit it to the clerk in advance. All public comments, not including the parties, that is city staff or the applicant, will be limited to 3 minutes. Public comments are not permitted after the public hearing is closed. With that, open the public hearing. We're going to start with, first on the agenda is 24-0009, appeal. And BZ case, variance from UDO Section 1115.01E3A to allow a front yard fence.
That's probably from the
That's from the
last-
previous one,
Yes.
isn't it? Sorry. This is an appeal administrative determination for the parcel IDs that are there in the hearing, and this is a continued one from the previous year of 2024. All right. So, public hearing, did we actually close it, the public hearing, or are we reopening it? Mr. Legal Director?
It was postponed for a number of reasons, for more information, opportunity from the applicant, for personal reasons as well. So I would advise to reopen the public hearing at this point to determine if there's any additional testimony on behalf of the applicant and to get an update from city staff as well.
All right, sounds great. Then we will open the public hearing here for this case of 24-0009 at 6:06. All right. With that being said, do we have anyone, I believe, for this case would like to come to the podium and with any additional comments?
Gentlemen, this is Matthew Sorg. I'm the attorney for the appealing party on this. If you recall, we were here in September, and we were here. We had some discussions at that point in time. You asked me to do some photographs. We did some photographs, brought this back to the October hearing. Then there was an issue with the public health water issue that we wanted to report. So we continued that from the 22nd. We got that on the 30th. Then we did have to continue the December hearing because one of my clients was ill. So we have submitted that report from Ms. Hoodle, I think I'm saying that correctly, that talked about that this, we were in compliance as a custom machine shop with the wellfield overlay, and I believe that has been submitted to Ms. Holt as for tonight also. So ultimately, our position is the zoning violation basically says we're a storage facility. I think the evidence we presented, photographs, replete with that this is a custom machine shop. It's always been a custom machine shop. Along with my clients have been in possession of it. There were some notes in the packet from the city that talked about some criminal actions. Those were dismissed. There's nothing to those either. So ultimately, we're not a storage facility. It's not been our primary use. We've shown the custom machine shop. We've satisfied the Wellfield Public Health Montgomery County. She said we're doing just fine with that, and we've submitted that to the board.
All right, do we have any, maybe additional questions or anything to the appellant?
So I guess my question for Naya, the outside material, was that ever an issue with the well water? The outside, the stuff in the back of the machine shop?
So you mean the
Whatever that,
vehicles
cars
stored?
and boats, whatever that is.
There is a time frame for items being stored if there is gasoline in those vehicles, and I don't want to misspeak and say what that time frame is, but if they are drained of gasoline, then they would be in compliance. But if they are not, and they are outside of that time frame, then they would not be in compliance.
Okay. Do we have anything with gasoline in the,
Well, if you look at the page 2 of the October 30th report from Sarah Hodel, the Wellfield Protection Specialist, she lists all the chemicals that were on site and the appropriate volume or weight of them, because there's a weight restriction, I believe it's 160 pounds or 20 gallons. So she addresses that in her report on page 2, which is attached to that. And again, to quote her, inspection conducted at your custom machine repair shop on October 1st, 2024. She went through the building, chemical capacity, total maximum daily inventory. This property is 20 gallons, 160 pounds. Therefore, you comply with the source water protection program. I left some things out, but that's the gist of it.
All right, any other questions? Here? for the appellant? Mr. City Manager?
I actually just have a question, really briefly, actually, for the law director.
Sure.
As a point of order, just to put my own ignorance on display, if you'll refresh my memory. The public hearing was opened at a prior meeting, and so now we're at a position where we're hearing public comment. And then is there a period of time where staff jump in with their update as a part of that process? Is that before or after this public comment period concludes?
Yes,
Or-
staff is permitted the opportunity, since we've reopened the public hearing, to provide any, whether it be rebuttal, any updated comments. There was from the chair and from this board some additional items requested from the applicant. So certainly in response to anything that may or may not have been received by city staff would update the board accordingly as well as to what has transpired since the last hearing.
And Mr. Roush, we usually get a packet, and I think there was one in September, and then there was one updated on October 22nd. I don't think we have one, at least provided to us today, but basically the only missing piece of the puzzle at that time was this well field.
Understood. No, thank you. It's been a while since we've had a continued case, and I know since this one has gone on for a few months, I just wanted to be sure I had the right spot of the process in my own head. So,
Yes, so
thank you. I
Mr. Manager,
appreciate that.
the city staff will be able to provide an updated status as to what has occurred and what has been received, and the staff's analysis of the same after the applicant has, through their representative, has presented this testimony.
Roger that. Thank
Thank
you.
you.
Appreciate it.
And just to follow up, I don't know, I think we had Mr. No talk at least at one of those hearings, and I would proffer that what I've said is what he would say. So-
No,
Okay.
understood. And again, we're refreshing our memories again from the last, since it's been 2 months since the last one. All right. Anything else for Mr. Sorg? All right. Thank you, Mr. Sorg. Anybody else in favor of for this appeal, 24-0009? I know we've got maybe two more up here for this. And you don't have to, but I know we got Roger No here. If you want to, if there's anything additional you want to say, you're welcome to. And there's also a Frank Smith. So either one of those would be fine. If just to open it up, and Mr. Frank Smith.
Yes.
All right, sounds great. Thank you. And
I state, my name is Frank Smith. The statement I'm about to give is the truth. I'm not real good at reading, but anyway, I don't know what the problem is, but I see no problem down there. His property is clean. You can go in other parts down there, down Byesville, and see property that are in a lot worse shape. I don't see, his property is clean. He keeps it mowed in the summertime. He keeps it up. I mean, you can't even tell there's anything there other than his trucks that he drives. And I don't know what the problem is. But if you're looking for a problem, there's places down on Byesville that are really needing to be addressed. I mean, if that's what you're picking at, there's places on Byesville that really need to be picked at. They really need to be addressed.
I get that about Byesville and some of the other areas, but we're specifically talking about this one here.
But
You know,
there is no problem there that I see, because I live just up the street from him, and I see no problem there. I'm glad that I'm glad he has a business there. Thank you.
thank you, Mr. Smith. All right. Anybody else in favor or against the appeal for this case? All right, this time we're going to close the public portion of this hearing at 6:14.
And I can give
And,
just a
Yeah.
overview of the case.
Yep.
And
I was going to open it up to you for, as far as the staff update, just to,
as you recall, this is BZA case 24009 at the aforementioned address 4620 Springfield Street. So we are talking about a property that is in the B2 business district. This was a property that was rezoned in 2013. The applicant did have an opportunity to contest this or to go through the certificate of non-conformance process during that time. They did not do that, and it moved forward under the area-wide rezoning, and that is why you see that it is now B2, and it is operating or not operating as a business. We cited as such, that it was industrial use in that zoning district. Just to give you an idea of what property we're talking about. So the timeline you saw earlier in that statement, just to give you an idea, we did send a violation, an appeal was submitted. There was a consultation for the source water protection program. We do send emails and give notice of documents being provided. We did receive some of those letters, or I would say photos that you asked for. Staff did ask for additional documentation of what business was being provided or being operated there. We did not really receive those in September after the first meeting. So we did have continued email correspondence with the representative of the applicant or appellant, asked for that documentation. That was not supplied at that time. A source water inspection did take place in October, following several other meetings that we had. After that, we did get that documentation and other ones that you see in your packet, which was basically about the sale of that property, but not what was supplied. We did note that in August of last year, they did apply with the Secretary of State to register their business. So the appellate's position, from what we could tell from their application and throughout our communication, is that the primary use is a machine shop, that it has been in continuous use, and that is what they have said, like I said, through continuous communication, that they work with former Riverside employees to secure that non-conforming. However, the only documentation we have is that there was a letter from 2012 where they asked for about annexation and not about getting grandfathered in or pursuing that non-conforming rights. And this is that letter I'm referring to where they asked about annexation, which is also in your packets. This is one of the photos that is in your packets where you can see lots of materials. Another one, and per the minutes from that October 22nd, Mr. No stated that he's only at that place a couple times a week, maybe a part-time person, but does not indicate that he has registered that business with the city at all, and has only recently registered it with the Secretary of State of Ohio. And as mentioned, here's that registration, the Secretary of State. So we did not receive really any supporting evidence of that business. There's no city or county records of that business. Evidence shows that it's primarily used for storage of that machine shop or whatever it's doing, just storage for a business that's outside of the city. There have been past violations for storage, which again is in your packet, and some of those photos that you see do confirm that, or most of those photos do confirm that it's not really an active business. They did not pursue that legal non-conforming rights process. A longtime employee of the city has not observed an active business. The last information we do have for a business there was from 1997, and this is from one of those applications from that business from 1997 that you see on your screen. The owner was aware of the implications of that zoning, as indicated from their testimony at the 2012 Planning Commission meeting, which those minutes, again, are in your packet, and did not choose to pursue that non-conforming process, which would protect her from anything and grandfather her property in from new zoning changes. So we do maintain that the code violation stands and recommend that the board uphold those zoning violations, which are that they are operating a business in B2 that should be in I1, and that it is a storage use in the overlay. We've gathered that evidence, but the city has gathered that, or kind of outlined some of that in the presentation, and they failed to provide evidence that we erred in our interpretation of the code. So I went over those violation details. Storage in I1, which is storage in B2, which is only permitted in I1. They did not pursue or establish non-conforming rights or grandfathered rights. And again, conclusion, those zoning violations should be upheld, and it is your job to see if that interpretation is wrong. So, any questions?
Naya, we're not here this evening to grant a non-conforming.
You're not, no.
Okay, just wanted to make that clear.
No.
They would have to go through the process of making an application and then.
Yes.
Okay.
Mhm.
Any other questions for the city?
And Naya, and the argument that the property is now within the Water Source Protection Act, so that's not an issue.
Oh, it's been for a while.
So you're stating that it still is?
Mhm.
Yes.
Even?
Absolutely.
Yeah.
Okay. Because it's zoned as a B2.
So it's got two layers of zoning on it. It's got the B2 zoning, and then it has an overlay of being in the water protection area. And with that, they have to comply with the overlay standards, and one of them is, yes, having the proper storage of materials, but also there are use standards as well, which prohibit the use of storage as a primary use.
So am I correct that the violations have been since 2010? Because I see one in here for 2010 for
They're on
storage,
and off.
outside storage.
On and off, yes.
So has it ever been corrected, or has there ever been a final, we're done, we're okay?
Like I said, this has been on and off. The case has been closed. One reason the fence was erected is to hide probably some of that storage. But that's,
Okay, okay.
Anything else for the city? All right. Again, just to remind everybody, we're looking at, did the city err in their decision on whether or not this is determined as storage or not, and whether or not the applicant, or appellant, I should say, provided any information to disprove that the city erred in that judgment. So that's what we're looking at there with that. Any other questions here for us? Discuss anything specifically? No? All right. Then I move to a motion here to uphold the staff's determination in the BZ case 24-0003. I'm sorry.
9.
It's 24-0009. On 4620 Springfield Street, based on the standards of the UDO records of the case and evidence and testimony heard of the public meetings, I find that the staff did not make an error in their determination to cite the property in violation of the Riverside codified ordinances as a storage facility in the B2 zoning district and WP overlay district or water protection. I find that the applicant did not meet the burden of proof and did not submit sufficient evidence to support their appeal in arguments. Do I have a second?
Second.
Madam Clerk?
Mr. Cron?
Yes.
Mr. Walling?
Yes.
Mrs. Carpenter?
Yes.
Mr. Gosnell?
Yes.
Mr. Tiefert?
Yes.
All right, motion carries.
Attorney Sorg, under the BZA's bylaws, a written determination is required to be submitted to you as the applicant's representative within 30 days of the hearing. If you have any questions in the time being, you can feel free to reach out to me. All right, thank you.
Thank you. All right. All right. Now we're going to move on to BZA case number 25-0001, first one for the year. This is for 2337 Valley Pike, an appeal under UDO Section 1103.13E to allow an expansion of non-conforming residential use in the B2 General Business District. Madam City here, would you, or, this is, in just a minute here, we're actually going to, we're going to hear from the city first on the case here. Sorry about that.
Yes.
And you can just give some information about the case here, okay?
Just because we did things a little differently last time, I'll spare it now.
Sure.
I, Naya Holt, affirm that the testimony I'm about to give before the Board of Zoning Appeals is correct to my best of my knowledge. Address is 5200 Springfield Street. So this is BZA case 25001. I'm not going to repeat the address. A little background about this property. This is in the B2 zoning district. However, there is a house and a garage on the property, as you can see in the aerial map. The appellant went through the process to get a certificate of non-conformance. The property was built in 1955. The house and the garage was built in 1970. And so there was sufficient evidence for us to grant that certificate of non-conformance. How this came to our radar, however, is our code enforcement officer noticed that there was a shed and another structure that was built without permits. So that's how we're here today. However, through this process, after going through that process to get that certificate, they did submit a appeal to allow an expansion outside of that certificate to allow additional structures with the residential property. And in order to allow that, the board is the body that allows an expansion or a change of a non-conforming use. So right now, that non-conforming use is a residential property within the B2 Business Commercial District. And that certificate only covers that garage and that house. So they are asking today to allow for a shed and a additional accessory structure, which is a safe structure for a pet enclosure. Now, we found that typically these lots obtain permits. We've worked with a lot of residents to get that knowledge out, that sheds require permits. We have worked with Katie especially to get that information out. So there was a resident in this neighborhood who has called, and they were not able to have it because their property was non-conforming, and they were not interested in going through that process, so that they did not build that. So in keeping with that same line, the expansion of non-conforming properties is not really supported if we are keeping consistent with that in the code and with our comprehensive plan. So just to give you some more context, here is a copy of the certificate of non-compliance and the letter that was accompanied with it to let her know that she was granted non-conforming rights for her property in that residential use. This is the front of the subject site. You can see it is a house. It is an older structure. This is what that property looked like in June 2024, just the house, just the garage. This is what our code enforcement officer found a few months later. So from her application, this is what she is claiming and why she is wanting that expansion. It has been grandfathered in. It has been legally non-conforming since November of this year when we granted it. The additional structures were erected. They won't be permanent per her application, but they would be used for pets and a business. This is what the auditor's site has for her summary, and that is why it was only granted for the house and for the garage, because that is the evidence we could find over and over again for what is covered for the residential property. So this is our analysis. Typically, these residential lots, they obtain permits, and when they fail to do so, it has other unsolved violations. We need to make sure that all the residential properties meet the lot coverage and permit requirements in our community for consistency. We've been, like I said, trying to work with our other residents to make sure that is consistent. All expansion requests must also align with the surrounding character and the land use plan, and previous expansion requests have also been denied. So just again, a reminder of where that area is, a more recent picture. And also to give you some relevant code. So this one is looking also at that non-conforming regulations. So when things are expanded, it's very strong in our code that should not be expanded, should not be enlarged. That is said over and over in our non-conforming regulations. So we are recommending denial of this appeal because it would conflict with our land use plan and with the consistency that we are trying to move forward with.
All right, anybody have any questions for the city?
I think I have a question. So Naya, when we do a non-conforming and somebody agrees to it, they are aware of the regulations. And then if they want to add a non-conforming, there's really no option there, is there? Because any expansion is null and void.
I mean, that's up for this body to decide.
Okay, but
But,
I'm just, the way it's written,
I mean,
yeah,
how our code is, it really shouldn't be expanded upon.
okay. So I
Because
guess-
we've gone through the comprehensive plan process. We've asked our community what you want this area to look like. We've worked really hard with our neighbors and stakeholders for consistency. We've gotten the word out that permits are required. We've worked on our process to make sure those permits are being turned around more quickly.
okay.
So, can I ask,
Yes.
if they had came to the city and said, I want to put a shed up, and got a permit, would we be sitting here?
We would have talked the same way with the neighbor and said, your property is non-conforming, you could go through the non-conforming process, but you probably would not be able to expand.
Okay, so, but they never applied for a permit, but they were made aware that they needed to?
They never came to us.
Oh, they never came to us at all? Okay, I'm just trying to figure it out.
So so the appeal was submitted, but it was never obtained. Is that how I'm?
So this appeal is a little different because you guys are, it's not an interpretation of action, it's not administrative decision. You guys are the final decision makers when it comes to an expansion or a change of non-conforming.
Mr. Legal Director, could you?
Now, I do have a question on the expansion. So when we talk about expansion, are we talking about expansion of the original property, the main house or the main property there? Is that the expansion we're talking about, like
So an
a fixed
expansion
structure?
could be adding an accessory use, it could be adding pavement, it's when you're changing structures around, all of that is the expansion of a non-conforming use.
So to confirm, the only items that are covered in the existing non-conforming is the house and the garage.
That's correct.
Anything beyond that is expansion, which is non-conforming unless we approve here too.
That's right.
And Chair Cron, just to buttress off Ms. Carpenter's questions, it is a little bit of a unique type of appeal because there has been no, it's not a variance request, there's been no adverse determination at the staff level, like a permit denial or anything of that nature. It comes to this body as the first instance. Our code under the nonconformance sections indicate that a property owner that enjoys nonconforming rights can come to this body and ask for an expansion or a change. That being said, under UDO section 110313, there are certain requirements similar to standards for approval that this board is required to consider in determining whether or not that change or expansion is warranted. As Ms. Holt indicated, and the text of the UDO section was on the screen, the UDO sections regarding nonconformance are replete with references to very discouraged, very strictly construed nonconformance as to what was originally granted. You know, the point was that it was grandfathered in when a new code was issued so that the property did not lose the benefit of the rights that existed prior to the new code. That being said, as Ms. Holt explained, from a legal standpoint, any change, whether that be structural, use, anything like that is considered under law an expansion. What the applicant is seeking is to expand their nonconforming use that has been certified as legal by the city, and really the expansion pursuant to the city's determination, it's not supported by the code. Prior requests for similar expansions have been denied, so inconsistencies would be a problem. But again, this board is to deliberate whether or not the application before you meets the standards that support an expansion of a nonconforming use.
Thank you.
Thank you.
Anything else for the city? Thank you, Mr. Law Director. No?
No.
All right. So then we're going to go ahead and open up the excuse me, open up the public portion at this time at 6:38. And just a reminder, and just to, as you come to the platform here, just to speak into the mic and state the oath as well. And does Ms. Peterson, would you like to come up now to the podium? Thank you for your patience.
I, Melissa Peterson, at 2337 Valley Pike, Dayton, Ohio, 45404, affirm that the testimony I am about to give before the Board of Zoning Appeals is correct and to the best of my knowledge. I'm just going to read off the paper I brought. Hello and good evening. I am here because I received a notice in the mail addressing 3 issues. My food trailer being parked on the grass, for 1. 2, my storage shed. 3, my so-called chicken coop. My food trailer has since been moved completely off the grass line and into the driveway. And what was assumed to be a chicken coop is a catio, which was purchased as such, which is an enclosed structure, freestanding, not permanent, 8 feet, and movable. And it is further than 5 feet away from the property line. And it's not attached to my house. It's a place where my pets can go and stay out of harm's way. And addressing my storage shed, I was told in the notice that I had the option of obtaining a permit, but when I came down to do this, was told to wait till after the BZA meeting. I'd like to point out that my shed is not a permanent structure and is also freestanding over 5 feet away from the property line. And it's a professional build from 2024 that was delivered. And I am here today in the hopes of obtaining a permit for my shed and would like to keep my catio as well. And I am prepared to do whatever is required to be in compliance. And also, at the time the complaint was made, we were still in the process of moving in, so things were in disarray. So I could see how someone may have been a bit upset. And we have since gotten things organized, and this is my first time as a homeowner. So I'm sorry it came to this. So, thank you.
Thank you, ma'am. All right. Anything, any questions regarding that as well, the testimony there?
Mrs. Peterson, can you come up to the podium? I'm sorry, I have a question.
We'll see if the staff, or the board has any questions for you.
I read that it says here that you use your shed for business. You must do something.
I do festivals in the spring and summertime, and then a few Christmas shows. And there's no place there's a car in the garage, and I have big display cases that would scratch my vehicle. They're about this big, my glass cases, and I got maybe about 6 of them, and then some smaller cases, and things
Okay.
that would scratch the car. And the only other option would be taking it to the basement, and I'm too old to haul cases up and down the basement steps.
Okay. All right, thank you.
Sure.
I wanted to.
Does anybody else have any questions for the
And
appellant?
congratulations on your first home.
Oh, thank you.
Okay.
Any other questions for the appellant?
Nope.
What's the tubing that goes to the catalogue?
It's nylon. It's.
Is it for heat or for the cats to come in and out?
Yeah,
or-
they go in and out. That way, yeah, they just climb through, go into the catio, and then they could climb back into the basement.
Okay.
It's their tunnel.
A convenience for them
Yeah.
and you.
Yeah.
You don't have to open the door.
Yeah.
Okay.
All right, any other questions for the appellant? All right, thank you, ma'am. All right, close the public portion of this hearing here at 6:43. All right, go ahead. Are you directing to us to discuss or to the city?
Well, I think to Nadia, and I think to the city as well. So this is a B2, and she also is using the shed she has the house for live, but she has the shed for work. So explain a live work, no?
That requires a conditional use in yeah, that's a whole nother
That's a
ball
whole
of
nother
wax.
piece.
That's a whole
That's
separate
nother
thing.
I know, okay.
Yeah, let's-
That would
let's
go
not
before
get into
planning
that.
commission.
Okay.
Right.
That's not us.
That's not us. All right. All right, but what is us is that this is her residence. It's a B2. She has a business. She's using it as part of the business. Any thoughts on that?
No, because I don't think that comes into play here.
Because I know, because it's a
So,
residential.
so obviously
Okay.
what comes into play here
Is
is
the law.
the
Conforming use.
conforming, non-conforming conditional use stuff that
Well, it's-
we're talking about, right?
It's non-conforming, yeah.
And a lot of it has to deal with, if you take a look at the UDO, right, where it has to deal with, if it was a larger square footage of property, you'd be taking a look at it differently.
Yeah.
and things like that, permits be required and other type of things as well, as we have a smaller footprint, and that comes to play here with our property, here at this, with this one. Anybody else that discuss? Yes, ma'am. Yes, sir.
Does a dog kennel have to have a permit? I mean, if just a wild dog kennel with a
Are you talking
tarp
about
over the top?
in a residential area or
Yeah.
as a business, like an actual kennel?
No, as a residential.
It does not, but there are setback requirements.
It doesn't have to?
No, but there are setback requirements.
Well, and the catio is not what we're here about, right? It's about the
I mean,
shed.
it is one of the,
Oh, it is one of the things?
One of
From
the
a-
others.
It's one of the.
The shed.
From a legal standpoint, it's one of the expansions
Okay,
that is
okay.
requested. The non-conforming, the certificate of non-conformance is to
Just
continue
the
the
house.
residential use
Okay,
as established
Has to
by
be the
the,
house
by
and
the
the
records.
garage. Okay.
Exactly.
okay.
Anything beyond that, accessory structure, any other use, a business use, we are in a B2 district, but we're talking about a nonconformance. So that is what's before this board, is whether or not there's sufficient evidence under the nonconformance sections of the code that would warrant an expansion. Lot requirements, as Chair indicated, are legally a big issue in this case because the lot size and the lack of permits is spoken to in the nonconforming rights section of the code that this board must consider, as well as the comprehensive land use plan. Does the proposed expansion of nonconforming rights align with that land use plan? From a legal standpoint, it does not in this case. So those are the issues that the board has to adjudicate as to whether or not, as proposed, the expansion is warranted by the current UDO nonconforming rights provisions.
Nye, are all these properties on Valley Pike, parcel 1, 2, 3, 4, 5, 6, 7, are they all in B2?
yes, yes, they are.
And they are all non-conforming as well?
They have not gone through the process that she has.
Yeah, because I've seen some.
So you go up the road just a little bit and you're running to like Burrito King and.
Yeah.
Yeah.
And they've got some children.
Yeah.
Yeah.
Anything else, board? No?
This is why she's here.
Okay, if I could maybe ask a question again out of
Go right ahead.
ignorance and maybe for the benefit of folks that might be watching online as well. For folks that maybe also find themselves in a situation like this, what remedies may be available to them? Like, I guess the normal approach in this circumstance would be to go try to pull a permit or otherwise go before planning commission. Is that correct? To sort of plumb whether or not this is possible?
Yes, Mr. Manager, from a legal perspective, there are options for the applicant that are not as drastic as the extreme remedy of expanding a nonconforming use. Permit applications can be submitted. Live work was mentioned. That can go before planning commission. There are ways to accomplish what the applicant is seeking to do that do not go to the extreme. It sounds dramatic, but the code is written in a way that it's an extreme remedy to get an expansion granted of a nonconforming use. That is a very, very limited certificate of nonconformance. It doesn't conform with the zoning regulations of the district. So any use or structural expansion, any use expansion or structural expansion of that nonconforming use, it's a very high standard. Part of the legal analysis that is looked at if these kind of cases go to a appeals court is, or there are other options available that are less extreme than just a complete derogation of the zoning code and expanding nonconforming use. When it doesn't align with the land use plan, there are outstanding violations on the property. Our code does have separate provisions that indicate those must be remedied before additional permits and other types of those issues can be granted to a property. And so there are options, and city staff would be happy and has been happy to work with the applicant to come to a resolution that would be permitted by the code. The goal is always to help the applicant do what they wish with their property that, in a way that complies with the code, so that there are no need for variances, no need for expansions of non-conforming uses, and there are options in this case. And so that's part of what the city's recommendation is based on, is that there are less extreme and code-supported options that would allow the resident to pursue the types of things that they're asking for.
And how do we go, so that we don't make a decision that will be drastic and
Right.
something that she can't get around?
Right. So if this board were to take staff's recommendation to deny the application, I won't call it an appeal because there's no underlying
Okay, I like
adverse
that,
action.
application, okay.
An application to expand non-conforming use. If this board simply denies that, there are immediately other options that the applicant could take. The applicant would be linked with the Community Development Department to apply for permits. The city staff, myself, Ms. Holt, would be happy to work with the applicant to provide, again, other applications that could go before Planning Commission. It's not the end-all, be-all to deny an application to expand or change a non-conforming use. That would simply end that path, but there are many other paths available.
I don't want to get too far ahead of the conversation, though, too, because I think that, in fairness, part of the reason we're here in this process and in front of BZA this evening is because this case came to us without having had permits pulled and basically without having front-ended that work. And I think in fairness to the applicant and to folks that are watching as well, we have not done that front-end work to determine what some of these other options may be. So in fairness to everybody, like, we can certainly look at that, but I don't want to lead anybody on and suggest that we can absolutely get to yes here necessarily under our code. But I do think it's important to recognize that part of the reason we are where we are today is just by virtue of how this case came to us and the circumstances and facts of this case. Now, having said that, I think we would all agree that, yeah, that's our primary duty, is to try to figure out how to get to yes. But, and again, without kind of diving deep into the weeds of this particular set of circumstances, there are obviously the facts that we would have to look at in terms of whether or not another solution would work. But just based on what we've seen here this evening, I think there are other things that we would want to look at as well. As far as we have issues all over town with folks having movable trailers, coops, I don't know about catios specifically, but things like that will arrive on a property and sit for quite a long time, and they become inoperable, and then we're into property maintenance code violations. So there's just a lot to unpack here. But that would be part of the process that we would run any other applicant through when they came in to ask, hey, can I have a shed? Can I install a catio? What's permitted under the code? And at that point, we would be able to do that due diligence. And if it came to the BZA, we could say we've exhausted all other options. This would be the applicant's only remedy, et cetera, et cetera, et cetera. So that's a very long-winded way of just saying, I think in fairness, as far as how you're considering this case, it is before you, I think, in a way that, if it had followed, if the applicant had come in to try and pull a permit, the tone of this conversation would be a little bit different because we would have been able to do that due
You would have
diligence.
exhausted all those things, is what you're saying.
Right, we're just not at that point
So
yet.
we're at the end instead of at the beginning.
Correct.
Yes.
Okay.
Except we're at the beginning.
Right, but we're at the beginning,
But
yes,
we're at the beginning.
absolutely,
Yes,
absolutely.
correct.
And they came to you because having that right to appeal is one of their rights.
Right, absolutely.
They're exercising that.
Absolutely, and they should be able to.
We have that duty to bring cases to you when they're applied as is. So that's why we try to give some of that history, so you know what's happened previously and what possibilities are available after the fact.
Sure. All right. Thank you.
Thank
All
you
right.
very much.
Any other comments, board?
That answers
Nope.
my question.
Does it answer the question? You're good? All right. Then for BZA case, we're going to move to motion. BZA case 25-0001 for Appeal 2337 Valley Pike. This motion to deny the appeal applicant not met the standards for approval to expand a nonconforming use. I move to deny the applicant's appeal to expand a nonconforming use in BZA case 25-0001, 2337 Valley Pike, based on the standards in the UDO records of the case and evidence and testimony heard at the public meetings. I find the staff was correct in the recommendation that the proposed expansion of nonconformance does not meet the standards for approval in the UDO section 1103.13a and would be inconsistent with past requests for expansion if granted. I find that the applicant did not meet their burden of proof to support the expansion of nonconforming rights and did not submit sufficient evidence to overturn staff's recommendation. Do I have a second?
I'll have a second.
Madam Clerk?
Mr. Cron?
Yes.
Mr. Walling?
Yes.
Mrs. Carpenter?
Yes.
Mr. Gosnell?
Yes.
Mr. Tiefer?
Yes.
All right. And the city, Ms. Nile, and maybe even the law director or stuff, we'll be in touch with you for other things as well.
Is there any way I can obtain a permit?
Yeah.
You were saying that there are ways to go about that?
Well, the city will, first of all, you'll get within 30 days, you'll get a written determination from the BZA giving guidance as to what was decided this evening and the time being. You're welcome to contact city staff. We can schedule an appointment to discuss options with you that are available in light of tonight's decision.
Okay, where can I get a card?
Business card.
We're happy to give a
Naya-
card.
I have your email and phone number. I can reach out to you.
Okay, thank you.
Okay.
Thank you.
Thank you.
All right. We now have staff discussion topics. Does the staff have any present topics for discussion?
Yes, I have two.
Okay.
The first one, I'll be quick. We are in transition to phase 2 of our zoning code rewrite. That means we are working with our consultant and the steering committee to start developing that code, looking at different districts, those district boundaries. The first steering committee meeting for that phase will be later this month. So we're really excited to start moving into that phase. We're also going to be,
Later this month. You talking about the next 3 days?
I'm already in February. I am already in February.
That was sharp.
Thanks.
You're welcome.
Later in February, also in February and in March, we're going to work with our third graders at Mad River School District to get their ideas of what they want to see in a future version of Riverside. If they want to see more parks or more grocery stores or more playgrounds, things like that. We have, I know people at home can't see it, but there is a map in the back that's an example of the kind of maps that they'll be putting together. So-
Vending machines at every street corner.
Oh,
I'm thinking of third graders here.
okay, I love that. What are we putting in those vending machines though? I would love Capri Suns.
All right.
So,
That's
those
great.
at home, please be on the lookout. We're going to be putting some surveys. There are going to be community meetings coming up. Really excited to start moving forward with that.
Wonderful.
We definitely need the community input to make it the right code for Riverside.
Mhm.
And finally, the next thing is, it is that time. We need to start looking at our bylaws. I want to work with our vice chair on what those bylaws could look like in research. You know, maybe we need to tap some other BZAs, but they're about 3-4 years old now.
Okay.
So definitely time to look at them and refresh.
The vice chair is a perfect person.
Yeah. So, they can keep you in line, like, hey, that's not in the bylaws.
You got nominated. All right.
Yeah, I
awesome.
know, right? I'll remember that, Lisa.
She was the first one to name your name, too.
She did, yeah, I know.
She was the first.
That's what I get for speaking up for you.
Yeah. All right. Anything else?
So that's all I
That's
have.
it?
I just want to congratulate the chair and the vice chair on their elections tonight.
Thank you.
And Vice Chair Walling, you will certainly have the law director's assistance to review bylaws and procedural matters, so
Very good.
feel free to call on me anytime.
Appreciate that.
All right, thank you all.
All right, anything else from the board?
No, I just want to say that this was a really good meeting today. I think that sharing with the public, because we all assume that they know, or we know and they don't know, they don't know what, some of the things that we know. And so I think sharing with them and asking the questions, although we might know some of the answers, is really important. And I know it sounds trivial and time-consuming and basic, but it's important that, we share all the information that we can. So I thought it was great.
Who knows, maybe to get new board members, right? For people who may be interested or not, right? All right. We're going to go adjourn the meeting at 7 o'clock.
Right on.
Meeting adjourned.